Well, from right to repair hurdles to ongoing WOTUS litigation, that is, legal and tax issues, they keep rolling along for farmers and ranchers as we near the end of 2023. The man to break it all down, Roger McEowen with the Washburn School of Law, joins us now to give us a little perspective on this. As always, a pleasure, Roger. I thought we'd start with right to repair. I know at least 11 states have introduced legislation on this issue. So give us an update here.
Yeah, good to be with you, Suzanne. That's right. And what the issue is, of course, is when a farmer buys new machinery and the manufacturer largely views it as a technology lease. So the question is who owns the technology and therefore who can repair it? Well, you're right. 11 states have introduced legislation in the past couple of legislative sessions in these states, but Colorado is the only state that has actually enacted anything. And that new law starts January 1, 2024, and it's designed to make sure that farmers have the right to repair the equipment that they buy.
So talk about these antitrust lawsuits then filed by farmers against John Deere. They're set to proceed. So give us an update here. And what is this case, the potential impact on this legislation?
Yeah, there's about 17 farmers that have filed a Sherman Antitrust Act against John Deere. And John Deere was recently denied a motion in federal district court in the Northern District of Illinois, ironically not far from where the museum about John Deere himself is located, just on the Iowa-Illinois border. And he said that, no, I'm not going to give you a ruling based on the pleadings. The allegations are by those farmers is that John Deere has monopolized the repair market in violation of the Sherman Antitrust Act, and that's anti-competitive. And the court said that the farmers have standing to sue, and they're seeking damages going back to January 12 of 2018 to the present based on excess amounts that they've had to pay because of that anti-competitive conduct for repairs to John Deere machinery and equipment.
Boy, this case then is really important. We're going to see how that plays out. I want to switch gears, Roger. Now, of course, you and I have talked about this for many years. The legal challenges involving WOTUS, they continue. The current status of those disputes, where do we stand there?
Well, we have 26 states that have filed a legal challenge against the EPA and the Corps' regulation that they put out on September 8, purportedly in compliance with the Supreme Court's opinion last May. And the states are claiming that what the EPA and the Corps' new rule has done is really undermining state control over land management and doesn't really comport with the Supreme Court's ruling, which says that to be a navigable water of the United States, to be a WOTUS, you have to have a continuous surface connection. There has to be that continuous flow in that water course. And so the challenge is that the rule was promulgated incorrectly. It's usurping states' rights, and the challenges will continue. And then a couple of other states have other well-defined challenges to that, including the state of Texas.
Well, and I'm sure these legal battles will continue. Thank you so much for giving us an update on these issues. Roger McEowen with the Washburn School of Law. Always appreciate you being here, Roger. Thank you.